I would like to reserve 5 minutes for rebuttal.
Will you be arguing the,
No, it would just be me.
all right. How much time for rebuttal?
5 minutes.
All right. All right, you may proceed.
Okay. Well, good afternoon. As I said, I'm here on behalf of the appellants who are the original plaintiffs in this case, Carolyn Stark and Susan Lazenby. This is a case that was filed back in 2014 alleging breach of fiduciary duty against the appellee, Steve Mclean. There was a trial held on this in which the trial court found that Steve had breached, I'm going to refer to him as Steve because everyone has the same name in this case, in which the trial court found that Steve Mclean had breached his fiduciary duty in managing trust that belonged to the appellant plaintiff and his parents. This case went up on appeal, that was Stark 1, and was remanded back to the trial court to resolve certain issues involving prejudgment interest on money that was not put into the trust, as well as an issue of attorney fees. Those issues were addressed by the trial court in a hearing in December of 2022, and based on the judge's rulings, we are now here again on appeal. We're here on 2 issues. One is the trial court awarded prejudgment interest on the income that was not placed into the trusts at a rate of 2%. Our issue is that we believe this trial court abused its discretion in awarding 2% interest, mainly because there's no basis or findings that support that 2% that the trial court held. The trial court decided that because there was a trust account, which was not a trust account, it was the parent's personal bank account, but because that account was at a rate of 2%, that's what he used to base his judgment and finding that the trial court that the plaintiff should be awarded 2% interest as prejudgment interest. The trial court failed to consider his previous holding that Steve had breached his fiduciary duty, his responsibility to manage the trust assets.
Was there any proof put on as to what, assuming the money had been put in a trust account and not this checking account, which I understand the judge relied on what checking accounts were paying interest on at that time. Was there any proof put on as to, had the money been put in a trust account, what it could have been invested during that period of time?
Yes, sir. The plaintiffs had an expert witness, Robert Noble, who testified that a prudent investor should be able to get a 10% return on any investment, whether it had been in the markets or that was what the expert had testified. And the trial court did find Mr. Noble credible. So, and relied on Mr. Noble's testimony for every other award of prejudgment interest except for this instance. And so...
Was that the only proof to say that a prudent investor could get 10%? Is that the only proof on interest?
Yes, sir. I mean, Mr. Noble testified fairly extensively about what the appropriate rate should be because he had factored in 10% on all of his calculations. And so he had testified that that was a regular return on things and that...
Did he describe any investments he was getting 10% on?
Yes, sir. And all of that is in the record to what his testimony was regarding specifically. But his testimony was very clear that he, as a certified accountant, would not invest in anything that did not do a 10% return. And that's what he would expect to see. And so there's substantial testimony by Mr. Noble that 10% would be an appropriate rate. And the trial court didn't consider any of that. And that's why we believe the trial court abused its discretion in failing to consider that testimony from Mr. Noble.
And your expert's testimony about the 10% return, that was for what period of time?
Well, when we're talking about this, the trial was held in February of 2019, but he said, I mean, that was his testimony, was that would be appropriate just as a general investment at that time period. And when I think he had done his calculations November, the fall before, so 2018, but that's what he was considering.
Well, weren't we dealing with a specific period? It was the farm income from 2000 to 2007.
Yes, sir.
So, I mean, why would what you could get in 2019? How is that relevant to what I'm asking? Was there any proof as to what interest would have been available between 2000 and 2007?
Mr. Noble testified that in his 40-some years as an accountant, that 10% would be what he would expect to have on a return. So that would cover that same time period, that 2000 to 2007 time period. And that would be what would be necessary to fully compensate the plaintiffs, which is the purpose of prejudgment interest. And so it's based on those factors that we believe that the trial court abused its discretion. The second issue
Let me just inquire a little bit about that. So is the only testimony involving what interest would be the judge looking at what interest was from in the checking account that was not really a trust account versus the accountant testifying that it would be his expectation that there should have been at least 10% interest per year?
Yes, sir. And particularly relying on that 2% interest based on that account that we believe is just not relevant because it was not a trust account. So to just pull a 2% number from that account is not something that is not as credible or as relevant as the testimony of the plaintiff's expert, Mr. Newell.
What is it about trust accounts that just because it's, quote, a trust account earns more interest than any other account? I'm not understanding that.
Well, in this case, what they're referencing is the Newbern Trust account, which was not a trust account by any means. It was a personal bank account of the parents of the parties. And so this was nothing different than just a basic checking account that they were using. It just had the name of a trust account. Whereas if this had been invested through a prudent, investment company, that there could be a higher, it should be a higher rate than just a basic checking account. And that's what we mean by when we say trust account, that there should have been some higher level of investment. Of course, this money was never in any kind of account because it was all converted by Steve for his own personal use.
But there wasn't any testimony about what was the rate on bank CDs or anything like that at that time?
The parties had other CDs that had actually been converted by Steve along the way, and there was some testimony regarding what the rate on those CDs were at that time. I believe there was some testimony through cross-examination by Steve about treasury bonds. So there was substantial testimony from Mr. Newell about other rates of return that could be available for prejudgment interest, but his ultimate testimony was if you are a good investor and you're going to invest your money, you should be getting a rate of 10%, and that's what he would recommend as an accountant.
During the period in question regarding the 2% amount, who was in control of the funds that were held?
There were no funds held. Steve had stolen them all.
But for his actions, who would have been in control of those? Was that during the time that the parents were still alive?
They were still alive, but Steve was the trustee the entire time. So while they were the primary beneficiaries of the trusts, Steve was the trustee the entire time and had the responsibility, like the trial court found that Steve had the responsibility to manage the assets and had the fiduciary duty that entire time period.
So if I'm understanding your argument then, you are requesting that the interest be set on an amount that would have been generated by a trustee who was a prudent investor?
Yes, ma'am.
Okay, thank you.
And then shortly, our second issue that we raised was regarding attorney fees and the trial court's award of attorney fees. The plaintiffs requested attorney fees pursuant to the Uniform Trust Act 3515-1004. The trial court initially awarded the plaintiffs $480,000 of the fee requested, which was approximately $680,000 by the plaintiffs. When this came up on appeal the first time, Steve had raised an issue regarding expenses that had been awarded, whether or not they were outside of the guise of discretionary costs. And this court held that you could not determine what was appropriate because the trial court had not specified what were expenses and what were fees. It was just a blanket $480,000. And so on appeal, or when this went back to the court took that directive and determined that it had to be more specific in its findings and went through some 300 pages of attorney fee invoices and determined that only only items in the invoices that were directly related to the trust, that specifically said trust, would be counted and that the plaintiffs could recover those damages for. And so from going from 480, we ended up at 279 for attorney's fees and costs. And then the second part to that is where the trial court determined if we come back on appeal, if we appeal this and the trial court sends it, or the Court of Appeals sends it back again, the trial court would cut the fee again to $110,000 for fees and expenses.
Why 110?
The court, that is, the 110 is the $41,000 for attorney fees that are specifically related to trusts. Doesn't include trial time, depositions, or anything that. It's just if the line item on the invoice said trust, then he counted that. That's $41,000. And then he awarded the entirety of the fee for the plaintiff's expert, Dr. Parrott, who had to recreate all the farm income, and Mr. John Murrah, who is an expert in trusts, and then a portion of Mr. Newble's of his fee for parts that the trial court could specifically relate to the trust. And so we believe the trial court abused its discretion in the way it limited its own discretion in awarding that $279,000. We don't believe that he had to limit it at all, but the trial court says, the trial court's position has been that the statute requires him to limit that fee, and we just believe that's incorrect, and why we feel that the trial court abused its discretion.
What your issue, though, is you say the trial court erred in not awarding the plaintiffs 100% of the fees and expenses incurred.
Yes, sir. The trial court's position is that 3515-1004 says he can only award fees and expenses that are directly related to the trust. And the statute simply doesn't say that. The statute provides that as justice and equity may require, you can award fees and expenses, attorney fees and expenses. And so the trial court has been incorrectly interpreting that statute and using that to limit the fees. We understand that the trial court can use its discretion in order to award attorney fees, but the trial court, before it even gets to its discretionary authority, is saying, I can only award a portion of the fees because that's what the statute says, and that's just an incorrect interpretation of the statute. And that's why we're asking for the entirety of the fees to be awarded, because our plaintiffs, our clients have incurred those fees, they've paid those fees, and those are damages that they incurred in prosecuting this case.
All right, thank you. You have your vote.
May it please the court, I'm Molly Williams. I'm with Ashley and Arnold in Dyersburg. On the issue of the interest, today is the first time I've ever heard it said that the judge awarded the 2% because that's what the trust account was drawing. That is not correct. There was no discussion other than the fact that he did mention that if you did put it in an account, it wouldn't have drawn more than 2%. His reasoning was based on proof that had been presented earlier and the testimony of the appellant's expert, Mr. Dubel, that at no time could he remember that any CD or trust account had earned 10%. In the last, I believe on his cross-examination, he said that in the last 15 years, that he had not known of an account earning 10%. He said, in fact, that his checking account was earning 1.5. So the judge was not talking about, oh, you could get 2% from a checking account, and he didn't discuss anything about the time period. He just said he did not believe that you could have gotten more than that.
But the money was never put into an actual trust account. It was in a check. It was in Mr. McLean's.
Watt and Polly McLean kept.
Wasn't a checking account?
Yeah, they kept a checking account. Watt and Polly McLean they had an interesting way of investing, and it's in the record. They love CDs. So they put money in CDs, or they put money, and they kept money in their checking account. At one point, they did authorize one of their sons-in-law to invest some money for it, and it earned, according to the record, 3%. So what the judge was saying was, number one, you had no right to have that money during that time period because they were still living. And number two, there's nothing to suggest that it would have earned that much money if you had had the money.
Well, isn't that part of the problem with this case? Because the son had already been named the trustee, and the money should have been in a trust account with him as trustee. The money should have never been in that account in Watt's account, as I understand it, because the money was trust funds. It was trust money.
Well, even if he had put it in a trust account, the judge is saying it wouldn't have earned 10%. They're discussing what it possibly could have done if someone who was investing money had been able to go out and invest any way they wanted. It would have earned 10%. I challenged that, and I questioned Mr. Newble's opinion, because he said the reason he picked 10% was, number one, that was the most you could give. Number two, First Citizens stock earned more than that, when First Citizens National Bank stock is not publicly traded. You can't even buy it from the bank. And number three, that he felt that a prudent advisor could find it. I questioned him extensively. Interest
I
rates.
understand, but the judge in fact said that that the checking account where the money was placed in Watt's checking account wouldn't have earned more than 1.7%.
Your Honor, he never made any reference to that checking account. He said a trust account. There was no trust account. It was in a checking account. He didn't say
But
that
that's what the account was. It was a checking account, wasn't it?
Right, but he's not saying that account, no, it wouldn't, it didn't earn any interest. But what he's saying is they couldn't have just simply put it in an account and counted on earning more interest. And I believe that would be based on money market accounts, the kinds of accounts that are available. Yes, if you want to take your trust out and invest in all kinds of investments, you might be able to, but simply putting it in an account would not have produced that interest.
Well, that would have been, that money should have been in a separate account under the control of the trustee, and then the trustee could have invested that money at a minimum in CDs, couldn't he? Which was not.
Which would not have earned.
It may not have earned 10%, I understand, but I'm
It
just saying.
wouldn't have earned 2%.
It would have earned something.
Well, but again, this situation we have to remember is this: Watt and Polly Mclean had a life estate, so they were allowed to do anything with their money and put it wherever they wanted.
Not
The
with trust
trustees
funds.
should have had the money, but they still could have taken the money at any time.
You're saying that they set up the trust, and the money that was in that checking account was trust funds. That's one of the problems with this case, was that it was kind of fast and loose with the trust fund money, and the money, that trust fund money should have been in a separate account.
Right.
Shouldn't have been in their personal checking account, should it?
No, but that's how they did it. That
But
is
that's what they
exactly.
did.
That's what they did.
But it should have been in a separate account.
Exactly. But
under the control of the trustee.
But that still does not make an abuse of discretion on part of the judge that he did not think it could earn 10%.
No, I'm not going to argue that.
That it still does not make it. And as I said, Your Honor, that's the first time we've discussed it. As far as I think Mr. Newble was very forthright in saying that, you know, what he used to come up with that 10% was not well supported. As far as the failure to award attorney's fees, the appellant wants to argue over and over again about an interpretation of 3515-104. The problem is they don't cite any case law, and they don't cite the legislative history. If they think that the correct interpretation or the judges misinterpreted the law, then show us how it should be interpreted. There are no cases on it. They simply want to argue that it's not fair. Well, and they also want to argue that on remand that this court did not want the judge to go through and figure out what did apply to what part of the case had to do with the violation of the fiduciary responsibility. First important thing is to know, they love to call it the Mclean Trust. Well, that's not what it was. The Mclean Trust was a completely separate trust of which my client was not the trustee and had no interest. That was a Mr. Hopkins. The Newbern Trust were the trust where my client was the trustee. So a great deal of litigation in the very beginning had to do with the Mclean Trust. Not my client is not the trustee. Other parts of it had nothing to do with the trust that my client was the trustee of. So we have a situation where the judge had to look at what was a reasonable expectation of what should have been included in the trust, and that's what he did it. I don't believe he says anywhere that he only gave them credit for time entries that had the word trust in them. That doesn't make any sense because the Mclean Trust was also in there, and that does not appear to be what it was. What we start out with is 500 pages of billing for everything. No attempt was made on the part of the appellants to sort out anything that didn't have to do with Steve's breach of fiduciary responsibility. What they want to argue is everything had to do with that. Well, that's a stretch, because how do you say a trust that he had nothing to do with and he was not the trustee of is hooked to his trust? Well, the way you do it is you misinterpret the case law. And they look at a couple of cases and talk about the fact that they think everything is related. One of the cases, I believe, is the Hensley case, and I think that's really interesting because Hensley, the common core of the relationship there, it was a suit against a forensic unit of a mental hospital for violation of constitutional rights of the patients. So the patients were in a hospital in a certain place being handled by certain people. Easily distinguished from the case we have. The other case they like to talk about is ISSA, I-S-S-A construction. That involves a contract, one contract. That's not what we're dealing with here. What we're dealing with here is completely separate issues. This court has already heard and already ruled on an issue involving the gift of first citizen stock. That already been determined that doesn't have anything to do with Steve's breach of a fiduciary responsibility. I have tried, and I will say, quite frankly, being the limited number of pages you can have on the reply brief stopped me from doing this, but I've tried to point out places where enormous amounts of time were spent on things that have nothing to do with that. They spent hours and thousands of dollars discussing the ownership of property which had been conveyed to Steve prior to any trust being formed. Had nothing to do with any breach of fiduciary responsibility. He owned it, or he and his brother owned it. In fact, in the one instance, he and his brother had purchased it from the appellants. So they were arguing over issues that had nothing to do with this. They were spent, I believe it was $94,000 on a motion for summary judgment, which was not granted. This is to save money, you spend $94,000. How is that reasonable? How does that make sense? What Judge Childress was doing was taking the same approach that has been taken by other judges. And in fact, Your Honors mentioned that in there was a footnote in your original, what they call Stark 1 opinion about looking at across the board at how to interpret or what is included in an award under the Uniform Trust Act. What Judge Childress was trying to do was figure that out, and the way he was going through it was trying to look at what they claimed, trying to sort out what actually did apply. The same method was used in a case called Jeffrey Robinson et al. Versus the City of Clarksville, which is a Middle Tennessee case, 2023. And that involved the eminent domain statute, which allows for the award of attorney's fees in a very similar way. The judge there went through the billing and determined it was not detailed enough for him to understand which parts actually had to do with eminent domain. So he clearly went through the billing. And this, Judge Childress makes it perfectly clear that he has gone through the billing and tried to determine what actually had to do with the breach of fiduciary responsibility. He did award them a set amount of money, the $110, but he gave them additional money for the preparation of the case. He used what my expert witness, Bruce Smith, said would have been a reasonable amount of money to prepare the case, $275,000. So he didn't just limit them to what said trust on it, but he gave them time for preparation. As far as he did not question either the reasonableness of the fees that were directly related to the trust. So he didn't have to go through the factors in Rule 1.5 because he wasn't questioning the reasonableness. The appellants just keep arguing, none of this matters because they're entitled to all of their fees no matter what, because they're all related or they're all whatever. But I don't believe that is the law. The other thing, Your Honor, is I think that there is a problem with alleging that their constitutional rights have been violated. First, if you think your constitutional rights have been violated, you might cite some case law. Instead, what they do is misinterpret something the judge said. What he said was if it was sent back, that he had established what part of it was directly related. He knew he was going to give them that much money. He didn't say, I'm not going to give you any more. So if you think he violated your constitutional rights, explain to us how that happened or what happened on that. Your Honor, I think there's been a great deal of emotion and argument made during this case that is not relevant. Calling my client a thief, a liar, accusing him of all these things is not necessary, nor is it necessary to denigrate the chancellor. What we need to do here is put out the evidence that we have and apply the law as we know that it is. And that's what we're asking your honors to do. Thank you.
And that would result in an award of what for attorney fees?
I think the 279 is a little high, but I think if Bruce Smith thinks that's a reasonable amount, I think that's the amount that they should receive.
Okay.
I mean, that's the way I feel about that.
You have 5 minutes for about.
So just one thing on the prejudgment interest. The trial court did award 10% for every other award of prejudgment interest for every other category for farm income at different time periods. So the trial court did find that 10% was appropriate and supported by the evidence on every other area of prejudgment interest except for this one. And this is part of why we feel that the trial court abused its discretion. In regards to the attorney fee award, one of the things that there were a substantial amount of attorney fees incurred in this case. As the plaintiff's attorney, there were no records that were maintained. All of it had to be recreated. Depositions had to be done. Everything had to be figured out after it had already happened, and that did incur a substantial amount of fees. There was a motion for summary judgment that was filed in an attempt to avoid a trial on this case, as we felt that there were no issues of fact, that there was simply a question of law of whether or not Steve had breached his fiduciary duty. The trial court found that there were material facts, and so we went to trial, at which point the trial court found that Steve had breached his fiduciary duty. So, we got there in the end, but that was an attempt to do that. But we would say, and while we've argued that alternatively, because we do feel that the trial court can award all of the fees pursuant to the statute because of that as justice and equity language that's included in the statute. I know there's no case law interpreting this statute. I have searched every state that has the Uniform Trust Act. It's just something that hasn't been litigated yet. But we feel that that is a correct interpretation of that statute of 3515-1004, because by including that as justice and equity may require language, that gives the court very broad discretion to say you were the wrongdoer and the people who were suffered, the victims, should be compensated for that. They should be made whole, which is the point of damages itself, is to make our clients whole. One case I want to point this court to, and we've cited, is Ellis v. Dugan, which is a Court of Appeals case in which the Court of Appeals awarded victims attorney fees based on the wrongdoing of a power of attorney, and found that because we want to disincentivize this type of behavior, we want to say that people in a fiduciary position should not be allowed to take advantage of, convert money, completely fail to meet all of the obligations that are put upon fiduciaries. And so by allowing victims to recover their attorney fees as damages, that we would be supporting them and doing what the statute says as justice and equity may require. And so we think that case is very relevant to this case because it's a similar situation. In fact, the trial court held that Steve used his position as power of attorney and trustee to convert almost $300,000 worth of certificates of deposit. But the trial court didn't consider any of that in its award of attorney fees. It didn't consider the work that was done in recreating and tracing the certificates of deposit that were converted by Steve through over a multi-year period, through various steps of trying to conceal those actions. And so this is another one of the instances where the trial court has findings that say Steve did this. Steve used his power as, not just power of attorney, but his position as trustee to convert these CDs, but then it's not supported in his ultimate conclusion. And so that's ultimately.
Let me interrupt you for just a second. Did you raise the Ellis argument in the trial court?
Ellis came out after our trial. We did raise it on remand after this court had vacated the attorney fee award. So we did raise this to the trial court. The trial court has never addressed it in any of its oral or written opinions.
Thank you.
Also, the trial court found in its original opinion that was originally vacated, the trial court found the fees to be reasonable. The trial court found that based upon the 1.5 factors, that the skill needed was above average skill, that the hourly rate was a reasonable for the area, and that ultimately the fees that were charged were reasonable. So that's the direction we feel like the trial court should have taken, and it's just ultimately not what happened. And the reason why we are bringing this to this court again is that we're talking about an award where we have requested $680,000 worth of fees that our clients have paid, and that we feel that they should be able to recover, and that the trial court is simply not making our clients whole as the statute and the law should set forth. And so that's why we're asking this court to address those issues and resolve this, and hopefully maybe clarify some things for the trial court, because I think that's kind of where we've gotten off track, is the remand and then back and forth. It's made it more convoluted than it needed to be.
Thank you. Thank you very much for your argument.
Thank you.
We'll take the matter under advisement. We'll start again tomorrow.